Up until about 20 years ago or 25 years ago, when parties were able to settle their cases, they usually did so through informal negotiations between lawyers and oftentimes on the courtroom steps. And fortunately, there's been an innovation which basically helps to facilitate earlier settlements, and that process is called mediation. Mediations occur in conference rooms like these. The mediator is a neutral who's hired to, with one sole purpose, which is to get the parties to resolve the matter. You know, an obvious issue in discussing mediation is, well, who's the mediator? Typically, a mediator is an attorney, but in order to be a mediator, you have to go through some pretty extensive training on mediation skills. And if you think about it, a mediator's role is essentially to push the right buttons for the parties in each of the two rooms to try to get them to a place where they can resolve it. So mediator selection is incredibly important. Sometimes there's some confusion distinguishing mediation from arbitration. The key thing to understand about a mediation is that the mediator does not decide who wins or loses. The mediator may give his opinion about a strength or weakness in a case, but he's just giving an opinion. He's not deciding anything. An arbitrator, on the other hand, he is selected by the parties to decide who wins and who loses. And so, you know, an arbitrator will actually conduct a hearing with witnesses and real opening statements and real closing statements, and the arbitrator will be empowered to you know, issue an award or not. My firm's approach to mediation is to engage in a tremendous amount of preparation. This is oftentimes one of the best opportunities to showcase not only the legal skill that you have, but also the strengths that you have in your case. And the idea is, of course, to sow doubt in the employer's mind about whether or not it can prevail in this case.